स्टडी IQ IAS, अब तैयारी हुई अफोर्डेबल.
Hello everyone, I hope this message finds you fit and fine. My name is Shashank Tyagi and I welcome you all to Kanthas series on Indian polity based on Lakshmikant book. Today our discussion would be around salient features of Indian Constitution. So let's take first step. Indian Constitution is written Constitution. That is one feature. But what is the difference between written and unwritten Constitution? So you should not think that unwritten Constitution is not written somewhere. It is simply that the difference is that in case of written Constitution, there is a particular codified form. It means one document declaring that yes, this is the fundamental rule book. But when it comes to unwritten Constitution, series of laws are time to time declared as part of Constitution. Like example, Britain. So you can say that there, in case of written Constitution, these rules are thought during the process of framing, right? And there, it evolves with time, okay? Both can be considered rigid and flexible based on the ways amendment procedures are made there, right? When it comes to this unwritten Constitution, since Parliament is having power to declare which particular law is going to be considered as part of Constitution, that is why it is seen that Parliament is supreme where unwritten Constitution is followed. For example, Britain. In Britain, Parliamentary supremacy is there. But when it comes to written Constitution, because one rule book is considered as fundamental, that is why constitutional supremacy is there, right? Parliament has to adhere to the basic principles mentioned in Constitution, right? So here we see judiciary has limited power, like in case of Britain. But here we see judiciary has considerable power. Why? Because judiciary, Supreme Court in this case example, is considered as ultimate interpreter of Constitution. And interpretation of Constitution becomes important because India is having constitutional supremacy. All the institutions should work as per Constitution. Now, some of you might be having this question in mind. Oh, since Supreme Court is having more power in comparison to legislature and executive, what happens if judiciary itself trespasses some provisions of Constitution? What is going to happen then? My friends, Supreme Court, say highest, you can say level of judiciary. It is an office. There is a bench of judges. If they pronounce a judgment at some point of time, let's suppose, and which you are saying that trespasses some core principle of Constitution, then my friend, these bench of judges are not Supreme Court. Supreme Court is an institution which is bound by certain duties. You can file a review petition which may be heard by other bench, and other bench may have different opinion, and the different opinion will prevail then. So it means Constitution will prevail, okay? So, for example, you can take here unwritten Constitution Britain, written Constitution India, USA. Now, original Constitution had 395 articles, 8 schedule, basic facts. Now, why our Constitution is so lengthy? One is geographical factor, diversity is there, right? Diversity is there, so needs, challenges will be different. Historical factors are also there. Single constitution for center as well as state. But there are nations where states have different constitution. But in case of India, there is one constitution applicable for center as well as state. In our constitution, there is a dedicated portion for union, another dedicated portion for states, right? And special provisions are also there with respect to the challenges faced by states. For example, Article 371, right? Constituent Assembly dominated by legal luminaries. And if Constituent Assembly was dominated by legal luminaries, they wanted Constitution should be as elaborate as possible, right? The efforts was that this Constitution should fulfill the aspirations of Indian people, and there should be less, minimum possible ambiguity when it comes to articles in Indian Constitution. Although there's always scope of interpretation when we talk about law. And that is why our Jennings says that Indian Constitution is lawyer's paradise. Now, going ahead, Indian Constitution has detailed fundamental principles of governance and administrative principles, means how our nation is going to run. This is a picture of our preamble. Now, drawn from various sources. This is another feature. But can you say that Indian Constitution has copy-pasted provisions from across the world? No. Many people have this question, oh, why we have not created original constitution? Why we have different sources? The reason is, my friend, you are building constitution. It means you are going to mention various processes, institutions, powers. And these insights develop with time in political theory, from where these provisions are taken. So if some methods have already been tested somewhere and proved success, and if some methods have already been tested somewhere and they proved failure, don't you think we should learn from them? And we should have comparative analysis how these particular principles may be applicable in Indian context. That is why Indian Constitution has been framed after ransacking. B.R. Ambedkar ji uses the word ransacking, all the known constitution of the world. So for example, from United States, we took these prominent provisions: preamble, written constitution, federal structure of the government, fundamental right, function of president, vice president, independence of judiciary, judicial review, removal of Supreme Court, High Court, judges. Important. These particular, sources point, question has been asked. For example, which of the following provisions of Indian Constitution are not taken from US Constitution? And then they will have 4 options, and one option would be, say, nominal head president. So that statement would be wrong, because nominal head as president is taken from UK, right? Because there, head of the state is queen, but queen is nominal. In case of India, head of the state is president and president is nominal. But when it comes to United States, head of the state is president and president is real head, right? Means real power resides with president there. But in case of India, president is nominal head. Designation of prime minister is there. For example, in case of Britain, prime minister is having major power. But in case of US, they don't have any post for prime minister. Cabinet system of ministers, parliamentary form of government, we have taken from UK. Now bicameralism, speaker in Lok Sabha, single citizenship. My friends, here we are talking about features of Indian Constitution. That is why we need to consider what are the sources. But when we are going to talk about parliamentary system in detail, when we are going to start parliament chapter, then we need to identify the difference between British parliamentary system and Indian parliamentary system, right? If question is asking which of the following statements represent the parliamentary system of India, and if that one particular statement is a feature of parliamentary system, but that feature is not present in Indian parliamentary system, then you need to have clarity between how this concept of parliament evolved, what are the features of parliament, although we are going to discuss today as well, because this is also a feature of Indian Constitution. But when we are going to talk about parliament, then that we are going to talk about this model in detail. Now single citizenship, we are going to talk about this when we talk about this chapter, citizenship, speaker in Lok Sabha. But you should remember that these are the portions taken: concurrent list, language of the preamble, provisions regarding commerce, trade, Australia, Canada. Similarly, these are facts. Idea of federation with strong center, like Canada is having. But same is not the case when it comes to USA. Distribution of power between center and state, residuary powers with center. Ireland, directive principle state policy, election of president, nomination of members in Rajya Sabha. Japan, procedure established by law, important component of our constitution, specifically this phrase mentioned in Article 21. Now Russia, 5-year plan, fundamental duties, which were later added, right? Weimar Constitution, Germany, suspension of fundamental rights during emergency.
कई बार मन में सवाल आता होगा कि इस प्रिपरेशन को शुरू तो कर दिया है, मज़ा भी आ रहा है, तभी आप इस वीडियो में हैं, सीखने को तो मिल रहा है, लेकिन क्या उतना पढ़ा जा रहा है जितना इस एग्जाम को क्लियर करने के लिए ज़रूरी है? क्योंकि अल्टीमेट ऑब्जेक्टिव तो क्या है? योर नेम इन मेरिट लिस्ट। तो देखिए, कंटेंट तो सेम है, लेकिन कंटेंट को यूज़ करने की हमें स्किल डेवलप करनी है। कैसे होगी वो स्किल डेवलप? पहले तो भाई टाइम से हर एक सब्जेक्ट का कंटेंट तैयार होना चाहिए। अगर आप वो कर रहे हैं ठीक है, लेकिन इफ़ यू वांट टू टेक हेल्प तो आप StudyIQ की हेल्प ले सकते हैं। जो StudyIQ का P2I प्रोग्राम है, आप StudyIQ ऐप या वेबसाइट पर देख सकते हैं। P2I मतलब प्रीलिम्स से लेकर इंटरव्यू तक का एक प्रोग्राम। तो ये एक प्रोग्राम के अंदर 4 फेजेस हैं। तो उस 4 फेजेस के थ्रू पहले ही फेज में आपका कंप्लीट सिलेबस हो जाएगा। तो इट इज लाइक द बेसिक थिंग, ये तो करना ही है। इसके बाद आता है कि हमें स्किल्स डेवलप करनी है, यानी कि उस कंटेंट का प्रीलिम्स में इस्तेमाल हो सके, उस कंटेंट का मेंस में इस्तेमाल हो सके, यानी कि आंसर राइटिंग। फिर हमें असेसमेंट चाहिए बीच बीच में, जिससे कि हमें कमियां पता लगती रहें। तो इसके लिए भी P2I में आपको प्रीलिम्स मेंस दोनों की टेस्ट सीरीज दी जा रही है। वीकेंड पर भी टेस्ट होते हैं, प्लस डेली मेंस आंसर राइटिंग होती है। तो आपको नहीं लगता अगर इतना कोई मेहनत आपके साथ कर ले, तो आप करना तो चाहते हैं बट एक पाथवे नहीं है, तो P2I प्रोग्राम वो पाथवे आपके लिए साबित हो सकता है। तो टेक हेल्प ऑफ दिस। फिर आपके मन में कभी कभी जो डाउट आता है उसको ढूंढने के लिए आपका काफी समय ज़ाया हो जाता है। ज़ाया इसलिए कह रहा हूं क्योंकि हो सकता है उस डाउट को ढूंढने के लिए आपने 1 घंटा लगा दिया, क्योंकि उससे एसोसिएटेड काफी सारी चीजें नई नई पता लगती चली गई आपको। ऐसे में इस टाइम को रिड्यूस कर सकते हैं आप। एग्जाम ओरिएंटेड क्या उस डाउट से रिलेटेड नॉलेज आपको चाहिए, वो आपको एक पर्सनल मेंटोर बता सकता है। तो इस कोर्स में फैकल्टीज तो आपके साथ हैं ही, इस पूरी जर्नी में आपको पर्सनल मेंटोर दिया जा रहा है। आप उसकी हेल्प लीजिए। आप कॉल व्हाट्सएप पर कभी भी उनके साथ कनेक्ट हो सकते हैं। उनका नंबर आपको इस कोर्स में स्पेसिफिकली आपको अलॉट होगा। तो अल्टीमेटली आपका टाइम बचेगा, कॉन्फिडेंस आएगा प्रिपरेशन में। फिर जैसे आप प्रीलिम्स क्लियर कर लेते हैं तो उसके बाद मेंस रेजिडेंशियल प्रोग्राम, ये इसका सेकंड फेज, मतलब थर्ड फेज कहिए, क्योंकि पहले फेज में फाउंडेशन है, फिर सक्सेस इन प्रीलिम्स है, फिर MRPM मेंस रेजिडेंशियल प्रोग्राम। फिर उसके लिए आप दिल्ली बुला लिया जाता है आपको। यहाँ पर आप मतलब जो फूडिंग लॉजिंग एवरीथिंग इज टेकन केयर बाय StudyIQ। और उसके बाद फिर रिगरस प्रिपरेशन होती है आपकी मेंस के हिसाब से, यानी कि हर एक जो आपका पेपर है, GS है, लैंग्वेज है, essay है, हर एक की तैयारी यहीं पर हम आपको अपने सामने कराते हैं। उसके बाद जैसे आप मेंस क्लियर करते हैं तो इंटरव्यू गाइडेंस प्रोग्राम, वहाँ पर आपके कोहोर्ट्स बनते हैं जिसमें डिस्कशन के थ्रू जो आपके अदर एस्पिरेंट्स हैं, जो आपके साथ इंटरव्यू देने वाले हैं, तो आप अपनी स्किल्स को पॉलिश करते हैं। साथ में ब्यूरोक्रेट्स, फॉर्मर टॉपर्स, ये सब फैकल्टीज आपको मिलकर गाइड करते हैं। फाइनली व्हेन यू आर थ्रू इनटू द मेरिट लिस्ट, देन फिर आपको लगता है कि हाँ, इट वाज ऑल वर्थ इट। मिलते हैं आपसे क्लासेस में, ख्याल रखिए। जय हिंद।
Now, our constitution is blend of rigidity as well as flexibility. Why I'm saying that? Because our constitution in Article 368 mentions procedure to amend constitution which requires special majority. But we also have certain areas where constitution can be amended by simple majority. Like if you have to create the state, separate state, if you have to means bifurcate the state. For example, Article 3, Article 4. So it means our constitution has given enough flexibility also. You should think why our framers of the constitution thought of having a mix of flexibility and rigidity. The reason is, if you make constitution amendment too flexible, then upcoming governments may abuse it, may play with the basic principles of Indian constitution, right? And that is why some rigidity need to be added to, right? Although there is Supreme Court, and especially after Kesavanand Bharati case 1973, it is also quite clear, although Article 368 gives power to Parliament to amend constitution, but this power is not absolute. You cannot play around, you can say change the basic structure of Indian constitution. And when Parliament asks, sir, what is this basic structure of Indian constitution on which our power to amend constitution are limited? Then Supreme Court said that we are going to tell on case-to-case basis. So it means ball is in the court of Supreme Court to decide what is going to be considered as basic structure of Indian constitution. So this scope actually is possible because judiciary was given this guardian role, right? So Constitution of India is neither rigid nor flexible. It is synthesis of both. Flexibility was given so that aspirations of the future generations can be met. क्योंकि अगर आपने rigid ज़्यादा बना दिया Constitution and demand in the changes, demand related to, you can say, if there are new challenges in the political system in future, and people are demanding certain changes in Constitution, but the hands of that particular government is tied. They cannot make that change. Don't you think it will reduce the legitimacy of Constitution? So that is why if you have to gain the legitimacy, then you have to be flexible also, rigid and flexibility both. Federal system with unitary feature. But you should remember, in Indian Constitution, the word federation is not used. Article 1 says union of states. It means Indian Federation is not the result of agreement by the states, not a state has the right to secede from the federation, right? So on this, there are certain phrases on which questions are asked. For example, quasi-federal. Who said? K.C. Vere. Quasi-federal means a mix of unitary as well as federal. Okay, when I say federal, so it means this is center and these are state. So center has certain areas in which center is having power. State is also having certain areas in which state is having power. You should also know that this concept of federal system actually evolved with demand for giving some power to the smaller unit which is part of that union. From there this concept of federal emerged. So why this emerged? Because it may be possible that small administrative unit might be having certain challenges which are different from other smaller unit, and that is why this smaller unit should have power to regulate the affairs of this area. So from there this concept of federal in polity emerged, and we took this in Indian polity as it was already there during the British administration, right? So federal system of government, it means there is division of power between center and state. We have Schedule 7, union list, state list. Indian government also contains many unitary. Indian constitution has unitary feature as well. For example, if I say state list is mentioned in Schedule 7, but it is not like that center cannot make law with regard to state list. There is scope also. If Rajya Sabha passes a resolution in this regard, that this is a matter of national importance, then Parliament can make law in case of state list also. And with regard to this Article 356 use, when president rule is imposed in a state, so there also it represents this unitary feature. So we are talking about unitary feature, but what is unitary feature? When power shifts towards center. And you should think, why our constitution framers gave more power to center? Why not equal power to state? The simple reason is there were chances of secession, there was differences, secessionist movement, possibility of secessionist movement, and we could not actually let it happen. And that is why for securing integrity, for territorial integrity, this power was tilted towards unitary feature, yani ki power was given more to the center. Now quasi-federal, apart from this, Morris Jones said it is bargaining federalism, because more power is with center. So with respect to finances also, for example, Finance Commission is there, and Finance Commission is a constitutional body which actually gives government the formula to divide resources between the revenue which government has collected between different states and center. Now this formula is given by Finance Commission. It is recommendatory in nature. It is actually prerogative of union government whether to accept it or reject it. Now the point is, which state is going to be given more funds? Who is going to decide? Center is going to decide. And there comes the play regarding bargaining federalism. So those states who are in good books of the center, majorly those states who have the same party ruling, which is ruling at the center. So in this case, state, center relations turn into bargaining aspects. Similarly, you have cooperative federalism. As Grenville Austin, it means cooperation is the essence of policy formation at the level of center as well. And Modi government has primarily pushed this idea of cooperative federalism. For example, Niti Aayog, another example GST Council, where state cooperation is considered necessary in key decision making. Now, Constitution of India is neither purely federal nor purely unitary. It is combination of both in the views of D.D. Basu. This is a cakewalk question. The word is cooperative federalism. So who used this word cooperative federalism? Abhi aapko bataya, just told you, Grenville Austin, right? So this is just an example that this kind of question are also asked. Now parliamentary form of government. This is another feature. Now the point is, what is parliamentary form of government? One, there should be nominal as well as real head. For example, nominal head in case of India is president and real head is prime minister. In case of Britain, nominal head queen, and when it comes to real head prime minister. Executive is part of legislature. It means those members who are part of this legislature, some of them will be part of Council of Minister. So it means there is overlap between legislature and Council of Minister, right? But same is not true with respect to USA. In USA's case, there is presidential form of government, and in presidential form of government, there is separation between executive and legislature, and that is why the key officials in Biden's administration, for example, Secretary of State, Secretary of Defense, they are not part of their Senate. Right, but in case of India, take a look on our Council of Ministers. They are either part of Lok Sabha or Raj Sabha. Right, our constitution says that if there is a minister, then this minister has to become part of either House of Parliament within 6 months from the date he is appointed or she is appointed. Right, so it means this overlap is there. Majority party rule and coalition government means you need to have more than 50% seat, either your party or coalition, means absolute majority is needed in the house, lower house, in Lok Sabha, in order to form the government, because this government will be considered as legitimate government to rule this particular area. Another feature, collective responsibility. What does it mean? It means Council of Ministers will swim together and sink together. It means this, if say Prime Minister resigns, then this whole Council of Ministers is going to resign. It means they are accountable to Lok Sabha. It means if they loses majority in Lok Sabha, then this particular government stands no chance to be there. Right? Prime Minister as the center of power, although the concept says primus inter pares, it means chief among the same. But the point is, traditionally it is seen that Prime Minister is more powerful than its other members of the council. Then parliamentary opposition, it is also crucial part of parliament, because parliament is there so that this parliament can function for the betterment of people, and betterment of people can only happen when there is someone to actually challenge this government, to make them accountable. That is why opposition is important. Independent civil service, so that administration have its own independence. Then bicameral legislature, for example Lok Sabha, example Raj Sabha. Now some of you might be wondering, oh, bicameral legislature, how is it connected to parliamentary system? My friends, please understand, I am using the word parliamentary form of government. Some of you might be considering, oh, parliamentary form of government means parliament, right? Parliament is different from parliamentary form of government. Indian Parliament is an example of parliamentary form of government. If I'm making a statement, just tell me what you think. It is true or false. Indian Constitution provide parliamentary form of government at the level of state as well as center. That statement would be true or false. Indian Constitution provides parliamentary form of government at the level of state as well as center. The statement would be true or false. Come on, fast. That statement is true, my friends, because parliamentary form of government at the level of state as well you have nominal real head different, governor as the nominal head, CM as the real head. You have all these aspects there, because executive, Council of Ministers at the level of state overlap with legislature. Right, so parliamentary form of government is present at the level of state as well. Okay, so this is one feature. Okay, means bicameral legislature. Although it is not necessary that every state should have bicameral legislature, it depends on the framework they are running until now. Right. Now the point is independent and integrated judiciary. Yes, this is also important feature of our constitution. Now independent, it means independence of judiciary means this judiciary will be having enough power to influence that this nation is being run as per the provisions which are mentioned in our constitution. It should be integrated. For example, this Supreme Court, High Court. So Supreme Court is the apex court, then we have High Court across different states, right? And when it comes to transfers of judges from one High Court to other, who has the role? Supreme Court has the role. When it comes to appointment of judges in High Court, who plays the role? Supreme Court plays the role, right? When it comes to making some interpretation on a particular constitutional aspect, so who plays the role? Supreme Court plays the role, right? And then it is followed by other parts, other High Courts as well, right? Now, that is why Supreme Court is court of record, along with High Court as a court of record. Now, Supreme Court at the top and the state high courts below it. Another feature, fundamental right. There was a debate going on in Constituent Assembly how many fundamental rights we should add, whether we should go with the word fundamental or we should have another set of words. So we agreed on the word fundamental. Fundamental means they are absolutely necessary. You cannot do anything against it. Means at least we should ensure this. Now, the point is, what was the need of fundamental rights? My friends, rights establish relationship between citizens and the state, means government. Rights give you a surety that at least these are the areas which will be protected, as well as in these areas your progress will be ensured by the government. Right? These fundamental rights establish the principle of limited government. It means government cannot trespass up this particular boundary. For example, there was a debate going on in Constituent Assembly that we should have more rights. Means although we agreed that Article 12, Article 235, we are going to include this in Part 3 of Indian Constitution. This was advised by Mr. B.N. Rao, legal advisor to Constituent Assembly, that let's make another Part 4. In that we are going to ensure adding DPSPs, Directive Principles of State Policy, where there will be socio-economic rights. And since government is not having enough capacity, and political atmosphere is not fit to ensure all economic and social rights, so that is why it was considered, let's do one thing. What can be mandatorily, done by government and which are absolutely necessary, let's put them in fundamental rights, and which we should expect that government should make laws in future, we can put in DPSPs, Directive Principles of State Policy. But you should know that fundamental rights are not sacrosanct, means they are not absolute, they are also conditional. For example, you have right to express, Article 19, subclause 1, subclause A, you have freedom to speak, right to express. Does it mean that you can express in a way which is actually threat to India's security? Do you think you can express in a way by which a crowd is being instigated and which may create riots? No, you can't. It means our rights are not absolute, our rights are qualified. Fundamental rights are qualified, means they are conditional. Writ jurisdiction are provided in our constitution, for example, Article 32, so that whenever there is threat to your fundamental rights, you can reach out to Supreme Court using Article 32. You can also reach out to High Court using Article 226. And from there, writ means legal order. So Supreme Court and there in 226 High Court can issue a writ so that your fundamental rights can be protected. But my friends, please understand, Article 32 is mentioned in Part 3. Part 3 gives Article 32, and Article 32 gives this power to Supreme Court. You can directly knock the door of Supreme Court, these fundamental rights are being abridged, then Supreme Court is going to take action for you, right? Apart from this suspension, Article 19 can be suspended only during external aggression. It means in case of emergency, and when this emergency, Article 352, is being enacted on the basis of external aggression. Because when we are going to talk about emergency, I'm going to talk about emergencies, external, internal. External में भी types हैं, तो वहाँ पर अगर external एग्रेशन की वजह से हो रहा है तो ही आप इमरजेंसी में आर्टिकल 19 को ले सकते हैं, नहीं तो नहीं. और आर्टिकल 20 एंड 21 यू कैन नॉट सस्पेंड, राइट. We are going to talk about these fundamental rights in detail when I'm going to talk about fundamental rights chapter. अभी हम हैं salient features of Indian Constitution. Directive principles of state policy. The word is state policy. It means policy to be made by government. When government try to make some policy, they should consider these principles as directions by Constitution. Although directive principles of state policy are not enforceable, not justiciable in court of law, it is not like if some DPSP is not met, then you can knock the door of Supreme Court, I want this DPSP to be met. No, this cannot happen. This can happen only in case of fundamental right, not in case of DPSP. Okay, so we can divide DPSPs into three parts: socialistic principle, Gandhian principle, liberal intellectual principles. And these are the articles associated with these principles. So socialist principles, where there is a foundation, or there is a duty put on the state, or you can say government, that you have to ensure the social well-being. For example, you have to ensure that there is no accumulation of wealth in this particular state, right? There should be equality in society. Those are socialist principles. Gandhian principles emerging from the ideas of Gandhi, for example, Panchayati Raj. Liberal intellectual principles, where focus is on minimizing the restrictions on the people and expanding the choices for the people. We are going to talk in detail when we talk about DPSP. Non-justiciable in nature, you cannot go in court. As I told you, in Mineral case, Supreme Court held that balance between fundamental right and DPSP. My friends, polity has evolved with the debate, who is superior, fundamental rights or DPSP? And this debate in judicial parlance started from the time of Jawaharlal Nehru, right? And then it evolved further. This is a beautiful evolution story of debate between DPSP and fundamental right. It is discussed when we talk about fundamental rights, Article 12 to Article 35, especially when I'm going to talk about Article 31, 32, 33, 34, 35. There I'm going to bring this debate in front of you, the whole story, different cases, in a simplified manner. Now, fundamental duties, they were not part of original constitution. It was Ms. Indira Gandhi as a prime minister gave this charge to Sardar Swan Singh that advise some fundamental duties for the people, because traditionally the concept of right, when they were added in our constitution, there was this debate, why not add duties also? Because if people of India are going to enjoy right, they should understand the duties also, then only this country is going to run. Then they agreed on this fact. No, our people are the one who are giving this constitution to themselves. This is the first line. And since this is a relation between, constitution establishing a relation between people and state, so it should be considered through these various provisions that people are going to do their duty. People should not be bound to perform a duty, because it may be possible using these provisions, government may start abusing people. Government may become, authoritarian. This was the fear in the mind when this debate was going on. That is why it was not added. But later, on the recommendation of Sardar Swan Singh Committee, these fundamental duties were added, but they were not made enforceable. This matter was given to Parliament that okay, fundamental duties are mentioned on for implementation of a particular fundamental duty. If Parliament deems fit, Parliament can make a law and even bring punishment if particular fundamental duty is not followed. For example, respecting our flag Tiranga is our fundamental duty or not, right? But punishment is not mentioned in our constitution. For that, we have a flag code, a separate code. Right? Recommendation Sardar Swan Singh Committee, 86 Constitution Amendment 51K was added. It is duty of every parent to send their children from age 6 to 14 years into the schools. India is a secular state. The word secular, where a state does not have any of its official religion. We have the Sarvadharma Sambhav as philosophy. And in case of India, our secular model says that a state can also intervene in a religion for protection of some fundamental rights. So India's model is different from the model followed in Europe. They have clear separation model, but we don't follow clear separation model, right? 42nd Amendment of the Constitution enacted in 1976 added this word in our preamble. Then debate emerged. If constitution framers themselves did not added the word secular, why Indira Gandhi ji added at the later point of time? Why she was so, you can say pushy about it? Although added through constitution amendment, it means Parliament has the role. But the point is, they did not added, constitutional framers did not added because they thought already there are many provisions in our constitution which themselves represent that India is a secular country. We have a right regarding freedom of religion ensured through fundamental rights, right? So, and why we should actually give the word secular, right? But she made it that no, we need to put the word secular because preamble provides the core philosophy of Indian constitution, so it should be applicable. It should be mentioned there. Constitution does not recognize it. It is not actually mixing of religion, state power. We have certain articles, as I told you, already mentioned that Indian constitution is built on this fabric of secular state. Article 14, equality before law, no discrimination. Article 15 says no discrimination on the basis of religion, race, caste, sex, place of birth. Article 16 says no discrimination when it comes to equal opportunity in terms of public employment, no discrimination on the basis of religion, race, caste, sex, place of birth, descent and resident, two more conditions. 25 says freedom of religion when it comes to practice. You can follow the religion of your choice, practice, profess, propagate, but there are reasonable restrictions. So we are going to talk about these fundamental rights when we deal with fundamental rights now, but you should know that yes, secular state, India's secular state can be evident from these provisions. Universal adult franchise, it means above 18 years of age. It means whoever is considered as adult. It may be possible. Universal adult franchise does not mean necessarily 18 years. First, you should keep this in mind. If law says we are going to consider adult about 21 years of age and they will be given right to vote, then that would be also considered a universal adult franchise. But in case of India, voting rights to the citizens are given to 18 years and above. Okay, so universal adult franchise. Single citizenship, it means dual polity is not there. It means you don't need a separate citizenship for the state. One citizenship as an Indian citizenship is enough to reside, to move, to work in India. But in case of US, they have citizenship of different state as well as citizenship at federal level. We are going to talk about this in detail when we talk about Article 9 of Indian Constitution. Then we are also going to talk about this in Citizenship Act 1955. Emergency provisions, why they were added. The word emergency itself represents that there may be some threat to the security and integrity of India, and in this case some extra layers of security are needed, and that is why our constitution mentions Article 352, 356, 360, 365, right? So national emergency, president rule, and financial emergency, right? So emergency provisions are there in our constitution as a feature. Which emergency has never been used in India? A question for you. Now, three-tier government, what does it mean? We have government at the level of center, at the level of state, at the level of local government. It means Panchayati Raj as well as municipal bodies. But why we need three-tier government? Was it an invention of our Constituent Assembly? No. Three-tier government was actually incorporated during the British time as well. Lord Ripon was considered as father of local government in India, right? So why three-tier government? Because certain basic services which are needed for the people at the local level, they will be best met when power is given to a government layer at the ground. That's why municipality panchayats were created. 73rd Constitutional Amendment Act talking about giving constitutional status to Panchayati Raj, 74th Constitutional Amendment Act giving this constitutional status to municipalities, municipal corporations. Independent bodies are also a feature of Indian Constitution. For example, Election Commission. Can you actually think of any successful democracy where Election Commission is not given independence? No. So our Constitution ensures free and fair election through independence of Election Commission. When we are going to talk about Election Commission, there is an interesting debate how Election Commission evolved, expanded its power without explicitly these power being mentioned in our Constitution. How during the T.N. Sessions rule, when T.N. Session, ex-IAS officer, when he was a commissioner of Election Commission, how he expanded these powers on this interpretation. Since Constitution mentions free and fair election, it means whatever power election commission is going to use on the basis of free and fair election, then that power will be considered legitimate, and even judiciary backed this interpretation with regard to powers of election commission. Now, CAG, Comptroller and Auditor General, very much necessary for financial probity in India, right? Then we have UPSC, SPSC. We are going to talk about them in constitutional bodies. So today you are actually having a walkthrough towards our in our constitution through this chapter, Salient Features. Cooperative societies. A stress is given on cooperative society. 97th Constitutional Amendment Act 2011 gave constitutional status and protection to cooperative societies. Why so much importance to cooperative society? My friends, the word cooperative, it means some people, some groups collate their resources together in order to provide solution to the problem which they were facing on ground. It is a step to tell that every solution may not be state-driven. Many solutions can be society-driven. That is why this fundamental right, this particular right should be given as fundamental right. It made the right to form cooperative societies as fundamental right under Article 19. ध्यान रखिएगा इसको. It included new directive principle state policy promotion of cooperative societies, 43B. It added 9th B in the constitution, which is entitled the cooperative societies. This is the importance of cooperative society, feature of Indian constitution. Now, what are the criticism? First of all, not representative body, not a sovereign body, dominated by the Congress, dominated by the Hindus, borrowed constitution, carbon copy of 35 Act, 35 constitutional, 35, because why this as a criticism? I told you when I was talking about historical background of Indian constitution, that Government of India Act 1935 actually had so many provisions that they were readily adopted by our Constituent Assembly also, because it fine-tuned the administrative structure during the British time. Then our constitutional framers thought, why not adopt this system which is already serving some purpose? Un-Indian or anti-Indian, it is said that, saying that many provisions are incorporated from outside. Un-Gandhian constitution, because Gandhian ideas of Panchayati Raj as the real government level self-sustained unit will be created at the Panchayat level. So those were considered as utopian ideas by majority of the members of Constituent Assembly, and it was taken, yes, we need ideals and gradually we will move in that direction. But elephantine size, among the lengthiest constitution of the world, paradise of lawyers, means huge scope of interpretation is there. So my friends, this was a go through towards the salient features of Indian Constitution chapter. I hope now these points will keep in your mind and you are going to practice some MCQs. PDF will be available in this Telegram group. Wherever you stuck, feel free to connect. I'm available Instagram, Twitter, Shashank Tyagi for you. See you in the next video. Till then, keep learning, keep growing.
StudyIQ IAS. अब तैयारी हुई अफोर्डेबल.